Thank you. We've heard a lot about the antitrust laws as being adequate to provide consumer protection in this area. I'm curious to know from either Mr. Burnham or Ms. O'Connor, who I assume you've practiced in this area, you understand antitrust law. So Ms. Livier has said that if we didn't have net neutrality, it would be highly unlikely that you would have been able to get your show on the internet. So I'm curious to know what kind of, in her situation, looking at that kind of a startup, Mr. Burnham or Ms. O'Connor, what kind of antitrust claim would lie that she could pursue? Are we talking about price fixing? Are we talking about tying? What are we talking about? What would she be able to proceed under to go forward?
Go ahead.
Well, I'm not a lawyer and I'm not practiced in antitrust law, so
Perhaps
I'm going
you
to
can
turn it over to
Ms.
Ms. O'Connor.
So having been in the internet law and policy space, again, my entire career almost, working in front of the Federal Trade Commission and in this area, there would be precious few remedies available under antitrust law. Your point is incredibly well taken. The limitations for a small individual artist or startup company or individual end user to avail themselves of redress under the law would be quite limited. And the phrase that keeps coming to mind is, your antitrust law is not good enough for my internet. It's just not comprehensive enough to protect the needs of the individual end user, the rights of the citizen. Again, it is a fallacy to say the internet has not been regulated. I was at a company in the late 1990s that had not only an FTC investigation, but 21 class actions, 12 attorney general investigations, a slew of regulatory oversight for the scintilla of an idea about a data matching project. It is wrong to say the internet has not been regulated by the FCC and the FTC for years. To not act right now would actually be the change. Senator Franklin's right. To not act would be the absence of the playing field that is open and accessible to the individual end user.
Thank you. I appreciate, Mr. Burnham, your pointing out that the technology has changed, so now our providers can figure out what the consumers are accessing. I think that is a very powerful piece of information for providers, and this is why I believe that the landscape is changing and why we're here today. Now, Ms. O'Connor, you mentioned that, and several of you mentioned, Title II is really probably not terribly applicable because Title II is a public utility. And we regulate public utilities up the kazoo, so this is not necessarily where we want to go. You also mentioned that maybe we should look at Section 706, but that may not fit either. So my question to either Mr. Burnham or you, Ms. O'Connor, is should we be talking about a new title?
We would welcome that kind of policy innovation from Congress or from the Federal Communications Commission. The internet is a precious and valuable space for the individual and for the end user and for small business innovation. And I am sympathetic to those claims that these are old titles that were based in historical parts of the economy that are very different. And we do not want to slow down the speed of the internet economy and growth. But given the options on the table, we encourage the FCC to explore all of the options, all of the opportunities, and we've seen some very creative hybrid approaches proposed by policy groups and by companies, things that would combine 706 and Title II to get the enforcement abilities of both, and we encourage the FCC to consider those.
Well, possibly in the best of all worlds that we would be coming up with a very clear new title, but in the absence of that happening, which will very likely be the case, that you're saying that the FCC, and I assume that Mr. Burnham agrees, that they have the authority to proceed under either Section 706 or Title II.
Yes.
To protect consumers. I mean, clearly consumers feel that net neutrality is important because all of us have heard from hundreds and hundreds and hundreds of our constituents who have said, make sure that we're not going to create an environment where they're going to have to pay differential rates for access to the internet. So my time is fast expiring, and I'd like to, well, Senator Flake.
I'll go quick.
Thank you. I understand that Senator Cruz is on his way back, so I would like to give him the opportunity to come back in time to ask his questions. So that being the case, I have a question for Ms. O'Connor. Chairman Wheeler has proposed evaluating certain practices of broadband providers under a commercially reasonable standard. Can you explain your concerns with that standard and why it would be a poor fit for preserving open internet?
Thank you so much, Senator. The commercially reasonable standard was only a relatively recent creation of the Federal Communications Commission, and it certainly goes to the commercial qualities of any agreement between various providers on the internet. But we think it misses the mark in an open internet proceeding. That is, we wish to protect the interests of the individual end user and the entrant to the market, not the established players. We seek a standard that looks more like something that protects the qualities of an open internet or does not degrade services to the individual. So we think that not only the language, but kind of the theory underpinning commercially reasonable, while perhaps completely applicable in other contexts under FCC jurisdiction, is not the right standard for a rulemaking proposal that seeks to protect the qualities of a truly open and flat internet structure that allows for low barriers to entry and a free market, a market that is open to all.
Thank you. Mr. McDowell, you have testified that the antitrust laws would be adequate to protect the consumers. So there's been discussion about the antitrust laws as basically protecting economic or an economic argument. So if the internet providers now know what customers are accessing, it would be a way for them to determine, without net neutrality rules in place, that they would want to have differential pricing based on what the consumer is accessing. So in that kind of circumstance, do you think that the antitrust laws are adequate to protect the consumer's right to access whatever programming and applications the consumer wants to access?
I do, and as I explain at greater length in the appendices to my testimony, more about that, but not just the antitrust laws, but general consumer protection laws, Section 5 of the Federal Trade Commission Act, for instance. You have state laws and other federal laws. There's, as I was explaining to Senator Blumenthal, breach of contract, tortious interference with contract. You have to remember that every major ISP has in their terms of service, their contracts essentially with their customers, these types of protections. If they were to breach them, the plaintiff's bar would have a field day. That's a huge deterrent right there. But let's look at what's worked, what has worked in this country to have a wonderfully blossoming internet ecosystem is the laws that are in place, that were in place before net neutrality came about as a government action, which was only 2008. The iPhone came about in 2007, and the app community started to, the app industry started to explode. So that's what's made it wonderful, is the marketplace, the market forces, and these general, flexible, more nimble rules that are in place that, as Noala pointed out before, in the 1990s, she was I guess at a company, or knew of a company that was investigated by the Federal Trade Commission, state attorneys general, and all the rest. What's better than creating a new body of law, which would create uncertainty and years of litigation, as Dr. Eisenach pointed out, would be for the government to sit down and sort of assemble a war council. I've called for this for years. Sit down, you could have the Federal Trade Commission, you could have the FCC, you could have the Department of Justice, state attorneys general, consumer groups, the plaintiff's bar, all sit down and say, hey, look, any of you, whether you're ISPs or you're search engine giants, if you act in an anti-competitive way that harms consumers, then we're going to come down on you. We're going to launch this avalanche of rules. But I also agree and wanted to speak to the fact that we sorely need to rewrite the Communications Act of 1934. We need to start over and look at all of this through the lens of consumer protection, knock down the silos that regulate based on your technology, whether it's copper or coaxial cable or fiber or wireless. All of those are regulated differently. From the consumer's perspective, they just want their stuff when they want it and to generate it, right? So they don't really care what the laws are behind the scenes. They're antiquated. They need to be rewritten. I hope in the next Congress we can get that done.
I see our witnesses nodding their heads, so there seems to be general agreement that we probably should amend the 1934 law so that it is up with the times. So pretty much, you agree? Well, maybe we can work on that. I see that Senator, I'm sorry, Ms. O'Connor, did you want to say something?
Couldn't agree more that consumers want what they want when they want it, and they don't really differentiate how they get their internet, whether it's on their mobile device or on their home computer or in the air. And I'd like us to all consider banning the phrase Internet of Things. This is not the Internet of Things. This is the Internet of people. So we want what we want when we want it, but we also want a level playing field to get in the game.
Thank you. Senator Cruz.